Hi, my name's Dawn, and today I wanted to share some information with you regarding the background facts in the case Kelly versus Fiander 187, a Supreme Court decision in which I was the party that won. Now, how it all began, on the 13th of September 2022, I was physically present in the Magistrates' Court in Albany when my matter was called. I responded immediately. I stood and I addressed the magistrate. I was very, very nervous as it was my first time in court ever. So I attempted to identify the capacity to which I was appearing, stating that I was Dawn Michelle, Minister for the Dawn Michelle Kelly estate, the natural executor for contracts for the natural private person. I was not silent. I was not absent. I was actively engaging with the court. The magistrate rejected this outright and refused to recognise my appearance unless I answered the very specific formula, yes, I am Dawn Kelly. No inquiry was made whether I was in fact the person named on the court file. The issue was treated as one of form, not substance. I was denied the opportunity to plea or be heard. And at no point was I permitted to enter a plea, contest the charges, or be heard on the facts or any defence. Instead, after a brief exchange, the magistrate stated words to the effect that the person is not Dawn Kelly, they have no standing to appear, they refuse to announce their appearance to the court, and they may leave. On that conclusion, it was reached that while I was standing there attempting to engage, she made up her mind. I was not refusing to appear. I was attempting to clarify how I was appearing. Now, the court then treated me as if I was absent, after declaring that there was no person properly before the court. The prosecution applied to proceed under Section 55 of the Criminal Procedure Act 2004 WA. Section 55 allows a court to proceed only when an accused fails to appear. I had not failed to appear. I was physically present. I was responding. I was attempting to participate. Now, despite this, the court treated the matter as one of non-appearance, granted leave under Section 55, and proceeded to convict and sentence me as if I was not there at all. Now, I have to add that this is a regular happening in the Magistrates' Court in Western Australia. I'm not sure if it's the case anywhere else in Australia, but definitely so here. Why this is a miscarriage of justice? As a matter of natural justice and procedural fairness, a person who appears in court is entitled to have their appearance acknowledged in substance, enter a plea, and be heard on the charges they face. What occurred instead of this was, because I would not adopt a narrow, predetermined identity formula, the court refused to recognise my appearance and treated me as absent. Now, that refusal triggered the use of statutory power that is meant only for genuine cases of non-attendance. I was then convicted without a trial. The core due process failure is the miscarriage of justice here is not about disagreement with the law, it's about process. I was standing in the courtroom, attempting to address the charges against me. The court chose to prioritise a technical identity formula over the reality of my presence and engagement, and by doing so, denied me a hearing. Form was elevated over substance. Procedure was used to distinguish or extinguish participation. Now, the bottom line, I was present. I was attempting to be heard, but because the court refused to accept any form of appearance other than a narrow statutory fiction, I was treated as though I was not there at all. This is how a conviction was entered without a hearing.